a lawyer. Of course, I'm expected to be the future mayor.
I'm a lawyer. Of course, I miss my first name. Di ba?
Attorney!
Thorns!
Thorns!
I am a lawyer and of course, hindi ako mayaman. Wala akong maraming pera. Maraming problema at saka stress. Oo, meron.
I'm okay. I'm fine. Quinchana. Quinchana. Ting, ning, 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 ning.
I'm a lawyer. Of course, power dressing is my thing.
Who got the power?
I was just gonna embrace it. Like, that's me. Yes, queen. Yeah.
I'm a lawyer. Of course, I accept manok, perfume, rice for my consultation fee.
Hey kid, you drop this. Put your crown back on and riddle me quick.
We're lawyers. Of course, wala na kaming social life.
Why are you running? Why are you running?
Papunta pa lang tayo sa exciting part.
Well, first of all, it is required for us lawyers to always update ourselves. No? By number one, of course, we attend mandatory continuing legal education programs. It is a requirement, especially for those in active practice. So, second one is, of course, there are always new cases promulgated by the Supreme Court, and of course, you have to read what are the current jurisprudence, just to make sure that we know we are still updated when it comes to the law. No? There are also, apart from jurisprudence, of course, there are new legislations that are coming out. This is something that we again read and we share to our clients so that they are familiar with what's happening, the policy environment, the legal environment that they operate in.
Nowadays, it's not really hard to stay updated regarding the changes in rules and regulations or new laws, considering that there are available resources online. And when a new law or a regulation is implemented, the affected agencies are also posting online, so we get to know about those laws online. So in my case, I just check the pages of different government agencies, and there are also some lawyers who will post the new law about this new law or new case decided by the Supreme Court.
Aside from mandatory continuing legal education or MCLE, I also teach law subjects in Mindanao State University College of Law. Teaching is one of the avenues where you can still be updated with the laws, no, and jurisprudence, because you will be compelled to study your lessons. Other means of keeping yourself abreast of the updates in the legal profession or in the laws and jurisprudence is to read newly decided cases, no, by the Supreme Court, especially those cases that are landmark cases.
In order for a lawyer to become an effective legal counsel, he must stay informed, dated of the changes in laws and regulations that affect the industries of his clients. So, in my instance, no, I regularly check updates through research, continuous legal research, and monitoring government publications, and subscribing to legal newsletters. Also, you can have this MCLE, the Mandatory Continuing Legal Education, wherein you're going to attend seminars through online or face-to-face, depende sa provider, for you to stay abreast with the current trends and best practices in the legal field. Furthermore, you also have the option of engagement or staying connected with your friends, your peers, your colleagues, and legal associations wherein you can communicate and discuss legal concerns and emerging legal issues. So with this, with staying updated and informed, you can effectively provide a timely and informed legal advice to your clients where they can use it to navigate through their legal challenges.
It is incumbent on the part of lawyers to keep themselves abreast of legal jurisprudence. And we are mandated to attend the so-called MCLE, the Mandatory Continuing Legal Education. It is a 36-unit topics. And it is done every 3 years. So, kung ano yung mga bagong batas, laws, amendments, ini-inform kami. So, kailangan meron talaga sa part namin to na alamin yung mga changes in law. And secondly, we participate, let's say, in information campaigns. May mga invitations kami to speak sa mga conferences, seminars. So we do it, and then sinishare namin yung mga bagong batas sa community.
I keep myself abreast with evolving laws and regulations by reading new issuances and relevant jurisprudence, by of course attending the MCLE and other relevant trainings and seminars or webinars. And I also engage in some discussions that require legal implications such as relevant social issues.
The act of refusing or participating in illegal activities as a lawyer is not only a matter of professional ethics, but also a fundamental obligation of every lawyer to uphold the rule of law, promote justice, and protect the integrity of the legal profession. So, in the Philippines, we lawyers are tagged as guardians of the legal system. So, we uphold the principles and values of the legal system, in which we are expected to exercise the highest standard of professional ethics. So by refusing to cooperate or participate in illegal activities, we help preserve the integrity of the legal profession, and in turn, it fosters public confidence and trust in the legal system in the Philippines.
Well, as a rule, a lawyer cannot reject a client except for valid reasons sa mga cases na confronting a lawyer, no? So in the public attorney's office, walang choice kami. We are mandated to help, to assist free of charge yung mga clients. And of course, kung sasabihin ninyo na refuse because sa tingin namin is hindi siya winnable, no? Wala pa nga trial eh. So the essence of due process is i-impose muna. No? So and also may mga mitigating circumstances naman. So pinag-aaralan niya may mga mitigating circumstances, and we see to it, no? Kahit na convicted man niya o ano, we see to it that the proper penalty shall be imposed by the court. So we keep on assisting. Hindi kami namimili ng clients.
Integrity is all what we need to have in the legal profession, especially that the confidence of the public in our justice system is gradually eroding. So people nowadays believe more in RTC or Rafi Tulfo Court, no? More than the regular courts. That's the sad reality. If there comes a time that I will be compelled to participate in illegal activities that will further tarnish the reputation of the legal profession and further lessen the confidence of the people in the court or in our legal system, I will politely refuse to take part of it.
Integrity is I believe, the heart and soul of the legal profession and the focal point of practice of the legal profession. And it is what makes the public repose trust and confidence in the system, in the legal profession itself. And ultimately, integrity will reflect our sense of accountability to the Almighty, given that the practice of the legal profession is just a privilege.
Of course, as lawyers, we are expected to be vanguards of justice, vanguards of doing the right things. There is always that temptation to take shortcuts, or if not, to undertake activities that directly contravenes the law. However, one must be able to draw the line by simply just taking a firm position kung ano yung pwede at hindi pwede mong gawin. No, at the end of the day, as lawyers, we want to support our clients, but we also want to sleep well at night.
A lawyer should maintain his integrity because it is the most important, or one of the most important assets that he should possess. Without integrity, a lawyer will lose his clients, and not only that, he will lose the trust of his colleagues.
Our country is admittedly not an ideal one, especially when it comes to its justice system. But I believe that as a lawyer, as a public servant at that, I have the duty to serve despite what is happening, because the country, the people that need our help are what makes the profession worth it.
If practice of law will give you an opportunity to make a difference, then it is always worth it.
Well, because we are officers of the court, and we maintain social order. So, kailangan pa rin natin na the people must be informed of the rights, knowledge, or legal knowledge, because we carry it every day in our lives, no? When we go to the market, may mga applications of law yan. May mga price ceiling, the bargaining, the contracts, obligations, the selling. May mga principles of law involved.
Here in the Philippines, the practice of law will give us a unique opportunity to serve the community. Especially here in Suralao, there are only a few of us here, so aside from being known to the public, we are also get to experience somehow favorable treatment from the public or from the people that we served before.
I think despite of it, despite of the fact that it's a bit slower than ideal, it still is worth it, because while it's not really the pace of the cases, but the certainty that justice will be committed, justice will be attained at the end of the day. Diba? Yun yung pinaghahawakan natin, na bahala na paunti-unti, mabagal, pero may patutunguhan yan sa huli. And that is where we draw our hugot as lawyers, no, na matatapos din siya sa huli. At yun yung, and when that day happens, when the promulgation happens, especially if it's a favorable promulgation, you'll find the fulfillment, no, as a lawyer, that finally the judgment has been rendered, and hopefully justice has been attained.
As you can see, no, there are many incoming lawyers and aspiring lawyers in the Philippines. That is because despite the challenges that are prevailing in the legal system in the Philippines, the practice of law carries with it an immense value and significance. So, first of all, you have here the diverse career opportunities that are available in the legal profession, coupled with the respect that is accorded to lawyers, which in turn, no, provides avenues for professional advancement and financial stability. Now, who wouldn't want that? So you have a chance for professional advancement, and you have an avenue for financial stability. Also, no, you have here the opportunity to provide positive impact. So you have the opportunity and the authority to represent those who are marginalized, to protect and advance their interests, and make a positive or affect social change in the community.
As a lawyer, I am just an advocate. My duty is to defend the right and advance the cause of my client in the court or any tribunal. To determine whether my client is correct or not is not for me to decide, but of the court, based on the rules and evidence.
Personally, I have my own moral scruples about this, but if we adhere to the CPRA or the CPRA, in criminal cases, the lawyer cannot decline representation with regard to his opinion about the guilt or the absence of guilt of the accused. So if he accepts the case, if the lawyer accepts the case rather, he has now the duty to make sure that the constitutional rights of the accused are protected, and he can also challenge the sufficiency of the evidence of the prosecution against his client. But all those steps and action should be taken within the bounds of law.
As a lawyer, we still accept cases that I might not believe in because, for example, the accused still has rights that need to be protected, like his right to due process of law. So, although I might not believe that he will win the case, or I might not believe what he is saying, I still represent him to protect his rights.
When you are confronted with a case that you do not believe in, and you are to accept that case, you have here now an ethical dilemma. So, the way I see it, there are two factors that you might want to consider. First is financial consideration. Maybe the client is rich, is able to pay. And second, you have here the sense of duty to legally represent the client. We lawyers are duty bound to represent those who needs representation to ensure that there is access to justice. So if ever that there comes a time that I have to accept a case that is against my personal beliefs, you just have to navigate through the situation by practicing or observing the principle of objectivity, in which case your personal beliefs should be separate from your legal arguments. In this way, while you advance and protect the interests of your client, you have to do it objectively. So your personal beliefs and your professional obligation should have this balance between them, in which you have to separate your personal opinion from your legal arguments.
Siyempre, lawyers, usually lawyers, they are professional and they know how to separate personal belief, personal disposition nila sa work related. So alam namin yan. We could really be objective in dealing with clients. Kaya hindi naman siguro magiging problema yon.
The practice of law is not really it is not dependent on you believing in a person at the end of the day. It is you making sure that the person's right will be protected at every stage or at every stage of the process. So you may have your own personal biases in favor or against your clients. But at the end of the day, those biases are not relevant, because you would want when a client engages with you, like in my case, I'm a private lawyer, the goal is not necessarily for you to win the case, but the goal is simply to provide the client his day in court.
So far, there was no instance like that. Most clients here are somehow respectful to the lawyers. What the lawyer will say to them. At first, they have their other opinions or view, but when the lawyer direct them what to do, most of them do not insist to do otherwise. So it's not really hard to obey the lawyer's oath.
So I became a lawyer in 2020. So in the span of 4 years, I only practiced litigation for 9 months. So in that span of time, I indeed experienced situations wherein my fidelity to the oath I took upon entering the legal profession was put to the test. So these situations normally arose when the interests of my clients conflict with the broader principles of impartiality, justice, and integrity. So one example I can give you, although I cannot give you the exact case and the name of the client, is where when I was tasked to represent a client whose acts I found morally questionable. So although his case had legal merit and he was entitled to legal representation, I struggled with the ethical implication of advancing or protecting his interest. So I had to set aside my moral compass and exercise objectivity and still provide a competent legal representation in order for him or in order for me to protect or advance his interest in the court. So it cannot be avoided. There are instances in the legal practice where you are confronted with situations that, just like what I had told you, hindi mo gusto yung ginagawa mo pero kailangan mong gawin in guise of making a legal representation, which is your duty as a lawyer.
What happened to the case, attorney? Did it push through or what?
So in that span of 9 months now, the case was still pending when I left the law firm. However, it was getting progress. No? It was progressive. So I should tell you ba kung anong klaseng kaso? So it was a case of child abuse, no? So we are on the side of the accused. And when I left the law firm, the case was leaning towards the dismissal of the case. So, yun yung isa sa mga kaso na I found na very against sa principle ko as a person, not just a lawyer, but as a person.
There are many instances. In fact, on a daily basis, your fidelity to the oath is always put into the test. The moment you get out of the house, you'll see the traffic. You'd like to shortcut. Diba? Parang there is always that temptation to break the law. Especially that there is, of course, the idea that being an officer of the court gives you certain privileges. But the truth is, being an officer of the court actually humbles you, so that you become more submissive to the law. This happens when it comes to clients. Whenever they have special requests, shortcuts, certain favors or shortcuts. But of course, what is important again there is you really have to explain the reason why clients make such requests for favors or shortcuts is because they are not aware of the law. So hence it is the duty of the lawyer to educate and to teach the client.
Yes, there were a lot of those instances, and there were instances where, of course, we know of the rules, we know of the law, but certain external factors and differing interests come in play that made me think where really I was standing. But at that instance, I knew where I stand and I stood by it. So I always do my best to stick to what is right, because at the end of the day, it's all about your integrity.
Well, to tell you frankly, kayo nga, first year, di ba? Ang hirap maging abogado. So, kumbaga, ang hirap muna maging isang law student, and then paano pa pasa ng isang subject, and eventually graduate. So, kung magiging lawyer ka na, parang ang hirap din na i-let go ang license, no? ng isang abogado. So, to tell you frankly, kaya nga pinili ko Public Attorney's Office. So this is the office na talagang very rewarding and mataas yung ano namin dito, yung level of integrity. At any time, we could be sanctioned, accountable. We have here to record our attendance. We have a biometrics and then a CCTV. Kita yan hanggang itaas namin. So kumbaga, in my practice, to tell you frankly, and I can tell you straight to your eye, na I did not do anything wrong because I enjoy my profession, and yung pagtulong lang sa mga may hirap, talagang makakalimutan mo na yung mga worldly na mga desires mo, no? Na kailangan bibili ka ng ganito, kamahal ka hindi, because you'll be with the poor. So kumbaga yung orientation mo is talagang really to help and be humble na kaya kasi kuminsan yung mga corruption, temptation, kuminsan greed yan eh. But in Davao, magtagal ka ba ng 18 years, hindi mo man-nurture ang greed. Kasi we're helping ang mga wala-wala. Oppress, so how can you develop greed? Walang pera dito, kaya nga free legal service. So, talagang ma-develop mo talaga dito yung talagang the best public service a government officer or employee can give to the people.
Fortunately, not a single instance yet. Since I am in government service, what I only have is limited practice. I don't have the luxury of time or liberty to practice law in full time. In that manner, my exposure to clients is also limited. If in case my fidelity to my oath is put to test, I would certainly not give in to the temptation, bearing in mind the oath that I duly sworn to when I became a lawyer.
Practically basic naman yan. When we say amicable settlement, amicable. Do not force the issue. See? Because when you settle it voluntarily. So, kung ang parties will not go into amicable settlement, then choice nila yan. Kung ayaw nila, and then go to court, proceed to trial. Let the court settle the issue and eventually decide the case. Because lawyering is not only settling the case. Siguro kung ma-settle mo before settle mo before sa opisina mo, because there is what you call alternative dispute resolution, well and good. But dapat yan voluntary. Yan. Hindi mo i-impose dahil para matapos na, hindi.
Unang-una, I have to again educate and teach them what is the value of settling amicably. No? Why is it important that when there's an opportunity for arbitration or mediation, not to just to also look that as a possibility. No? Ang nagiging challenge na naman dyan is the ego of the clients, no? Because it has come to a point where the ego has been touched, no, and that their position is already firm. But I also appeal to their practical. I do my best to be very realistic to them in terms of what to expect if they go through the process of litigation. Baka kasi hindi nila alam na the court process is not like nagkaso ka, bukas may decision na. That they will really incur a lot of expenses. They have to spend a lot of money. Diba? So, kung kaya nila yun, no, at gusto pa rin nila yun, edi go ahead. Pero kung nakikita nila that not one of the party will win, diba? So, they may consider. No?
In situation like that, first I just explain to the client their case and the probability that they might win or they might lose the case. So most of the time, the clients refuse to settle because of their emotions. I just explain what are the possible consequences if they will win and what are the possible consequences if they will lose. And most of the time, it is better to settle the case because you can control the outcome. You can negotiate with the other parties and you will know what will be the terms and conditions in the settlement. Unlike when they will not settle, it is the court that will impose penalties or something like that.
As we know, the CIPRA vests in the lawyer the duty to encourage clients to enter into amicable settlement when the case admits of a fair settlement. But in cases where you cannot convince the client, I believe that the client still has the last say as to whether to settle the particular case he is involved in. But the duty of the lawyer is only confined to encouraging such client to to accept the amicable settlement.
So you have these people very stubborn. So even if you're faced with cases that are unwinnable or clearly unwinnable, because of their pride and ego, they refuse to accept amicable settlement. Because of the reason that if they accept the amicable settlement, it would seem to the public that they lost. Which is not, kasi in an amicable settlement, it is a win-win situation most often than not. So handling clients who are stubborn, who refuses to accept amicable settlement in the face of unwinnable cases, poses a challenging ethical dilemma to a lawyer. So in this situation, the lawyer must delicately balance their duty to provide competent legal representation with their duty to protect or advance the interests of their client. So one approach I would recommend is to thoroughly educate your client by discussing the case along with its strengths and weaknesses, together with the risks and consequences that carries with it if it proceeds to trial. So in this scenario, it would help your client better understand kung ano yung kasong kinakaharap niya. So in this instance, it would present to him the practical realities and benefits of accepting an amicable settlement. So another option that you can give to your client if ever nagre-refuse pa rin siya mag-accept ng amicable settlement is that you have to explore the option of alternative dispute resolution. I think familiar kayo dito. Two of which is conciliation and mediation. These are less adversarial methods of settling disputes. In this case, however, there is more control on the outcome of the case compared to litigation. So if ever pa rin that the client still refuse to accept your opinion, first, sinabi mo yung strengths and weaknesses of your case, including the risks and consequences, ayaw niya. Second, sinabi mo, dumaan na lang tayo ng alternative dispute resolution through conciliation or mediation, still he refused. Then, you have to still provide competent legal representation to your client through excellent and zealous advancing of interest. So, ibig sabihin nun, even though clearly unwinnable yung case, you just have to do your part as a lawyer through excellence and zealous or zeal. So, for as long as you ensure that all of the options are on the table, and if those options ayaw niya, then you have no choice but to represent him in litigation.
It is a lifelong commitment and responsibility of any lawyer to keep himself more current with the laws and regulations that keep changing over time, because that is the only way that we can contribute to make the laws more responsive to the needs of the society, and of course to make sure that the justice system is really working given the demands of the current society.
So pag pinupush talaga ng client na medyo if it's a course of action that may be illegal or unethical, the client will just have to be very informed. The client has to be informed of what particular law will be transgressed because of the action and the implication of such action. No? Kasi, di ba, kailangan alam niya. No? And of course, as a lawyer, we should not participate if we know that the course of action to be taken by the client it will be an unlawful act. No? One philosophy that I embrace is what I would call the progressive legal practice. What is that? No? Or proactive legal practice. Ito yung bago pa magkaroon ng problema, dapat nagsiset up na ng mechanism yung lawyer to make sure na hindi na mapunta dun sa problema. No? Like for example, for the companies that I am the legal counsel, bago pa umabot sa possible court proceeding, I make sure already that the current policies will ensure compliance to the laws. So, ganun dapat ang standpoint natin. Yung parang, para dun pa lang, sigurado ka, it will not go towards an illegal activity or unlawful activity.
Parang prevention.
Preventive.
Preventive. Before yung curative na lang.
Yes. No? Kasi mahirap na yun. Pag halimbawa, mahirap din kasi yung parang, you just allow your client you're just an audience to your client's failing. Dapat malayo pa lang, alam na ng kliyente mo, oy, gagawin mo yan, in a matter of months, years, maiipit ka, and then you will be forced to do something that you don't want to do. Diba? So ayusin mo na siya, malayo pa.
I think in my years as a lawyer, I have not experienced a situation where I had to report a colleague for illegal conduct. However, if ever confronted with such situation, I think the act of reporting a colleague is a serious matter that requires a delicate and careful consideration. So first of all, syempre, hindi tayo agad maniniwala. You have to look at the allegations and make your own investigations. You have to talk to your colleagues, other colleagues, mentors, and even bosses, in order for you to effectively assess the situation or the allegation, whether the same is true or not. Second, if you found that the allegations are true, this is the time where you are going to weigh the gravity of the illegal conduct. Although illegal nga siya, there are levels to being illegal. They're grave, they're serious, they're less grave. So in this instance, you have the option whether to report it to the higher authorities or the authorities, civil service, mga ganon. Or if you are in a private sector, you're going to report it to your boss, your immediate supervisor, directly to the senior partner. So what you have to make sure in this scenario or proceeding is that you have to maintain confidentiality, Kasi in this proceeding, you have to minimize potential harm to all parties involved. So you have to maintain confidentiality regardless of the situation, whether alam mo talagang gumawa siya ng illegal conduct. You just have to make sure that you are impartial and you are doing the process with due process.
To be honest, wala talaga, But of course, hindi natin alam sa mga clients, mga clients. So we have this in the government 888 hotline, and of course we have this suggestion box or complaint box for the feedbacks if ever, So kung with respect to the question kung ako na i-report ko, wala pa naman akong na-i-report dahil wala naman akong nakikitang report.
Opo. Yung colleague na lawyers, attorney, ibang lawyers, wala din po. Outside PAO.
Outside PAO, wala naman akong kung may marinig man ako, wala naman akong personal knowledge with respect to that. Kasi chismis lang, yung mga ganitong narinig natin sa ibang lugar, sa sa Visayas o Luzon. So let them kung may mga evidence sila doon, pero kung within sa office namin na may personal knowledge ako, so far to be honest, wala naman ako.
Sige, I'll give the floor to Sir Paul, attorney, for his question. Thank you, attorney.
That's a no-no. Never ever encroach in a case handled by other lawyer. That's unethical. If the client goes to you for an advice, just politely tell him to disengage with his counsel first before you can give him or her your legal opinion.
As a matter of courtesy to other lawyers, we do not usually comment on the performance, no, of the other lawyers, no. But we zoom into helping and supporting the client, no. So unang-una niyan, we can actually give legal opinion without necessarily putting the other lawyers in bad light, 'di ba? So kasi meron din kaming courtesy, no, towards other lawyers, no. We do not engage in getting other lawyers' accounts or other lawyers' clients, diba? So, ang importante lang sa amin, masabi lang namin, matulungan lang natin yung kliyente, the party who needs legal opinion, legal help.
I believe that being a lawyer transcends legal representation. So it's also about bridging the gap between the marginalized sector who can barely afford legal services and the legal system. It is about reaching out to those people and making sure that they know what their rights are, what their responsibilities are, and that they have legal remedies that they can avail of. So the lawyer can serve as an instrument to empower those marginalized individuals to fight for their rights and to advocate for what they are really entitled to under the law.
You know, lawyers, no, they are not superheroes. So, one lawyer can only do so much. But as a lawyer, no, for me, to make the law socially responsive, no, you have to actively engage the communities. No? You have to, for example, you have to provide legal assistance to the less privileged, to the marginalized. We call this the pro bono cases. When you're going to represent a party in a court or a tribunal, but you're not going to get paid. Yun yung downside. But you're going to have this sense of fulfillment that you're helping a party or a person or a community navigate through legal challenges, achieving favorable outcomes. Second, no, you can also provide legal aid clinics wherein on your day offs, you can open your office and accept clients for legal advice without payment.
Part of the task of the Public Attorney's Office, and of course other lawyers, no, kasi we are also member of the Integrated Bar of the Philippines, no. We participate in barangay outreach programs, legal aid, no, to individuals who cannot afford, no, who cannot afford to pay legal services, no. Kami naman sa PAO, yun nga sinasabi ko sa inyo, na barangay outreach program, bringing the office nearer to the people, no, para at least ma-avail nila ang services without defraying expenses for the transportation, no.
So MCLE compels us lawyers to stay competent in a fun way, because actually the MCLE seminars are fun and the lecturers are experts in their own field, and some of the lecturers are also authors of the law book, so you get to know them and you will be more interested in learning the new laws.
Continuing legal education, I believe, sets the ethical standards of the practice of the legal profession, such that those lawyers who are equipped with the training, they become more competent, more effective in representing their clients and in fulfilling their responsibilities as a lawyer or as a member of the legal profession.
Lawyers in government service are bound by the prohibition imposed by law. And this is taking cases which are in conflict with our duty as public officers. That being so, our duty as public officers shall always prevail. Otherwise, we will be administratively liable.
As a lawyer, you are considered officer of the court automatically. Kahit na private ka, you have that public duty. No? So, yung harmonization, kasama na yan sa lawyering. Because lawyering is public service per se. No? So, kumbaga, swak siya. Pasok siya doon sa lawyering. So, wala naman akong nakikita na conflict na dapat o mga issues na dapat mo i-harmonize yung application of the law. Because basic lang naman you just apply the law, help your clients. That is public service.
So if you're a government lawyer, the act of harmonizing professional obligations and official obligations rest on a complex terrain. It is hard to do because your professional obligation and official obligation as a legal officer of an office or of an agency is intertwined. So there is no difference between your responsibilities as a professional and your responsibilities and capacity as a legal officer. However, when a conflict between the two arises, of course, your official obligation as a legal officer should always prevail. The reason is that public interest should always be the paramount consideration. So, sino bang nagbabayad sa iyo? Or sino ba nagbabayad sa iyo? Di ba ang gobyerno? So every time there is a conflict between the two, you should always consider public interest above all else. So, as a legal officer, you're always going to have or going to give impartial legal advice to the government, even though your personal beliefs as a professional does not align with the advice you are giving because it is most beneficial to the government. However, since you are a government lawyer, your interest or your loyalty should always be with the public. So, to answer your question, in cases where there is conflict between the two, public interest should always be above all else.
As for me, more than being a lawyer, I think I am first a public servant. But as to the question of how to harmonize professional obligations with official obligations, I think it is simply by doing your job and, of course, upholding the lawyer's oath to always uphold the Constitution, the laws of the land, and the rules and regulations. And if there is ever any conflict, I believe that I should adhere to the constitutional precept that public office is a public trust. And we should not do things that would compromise such trust.
Obviously, no. Just because you feel that the client will not be acquitted or you will not win the case, that is not a valid ground for rejecting a case. Now, we do have the Code of Professional Responsibility is very specific as to the valid grounds to rejecting a case. Part of which is, say, conflict of interest. So may mga very specific siya. So, and definitely your own evaluation of whether the case is winnable or not, or if the client can be acquitted or not, should not matter. Again, your duty whenever you represent a client is not necessarily to attain a desired result, although it's something that you will work hard for, but really your penultimate duty is to ensure that he has his day in court and that his rights will be protected along the way.
Again, we are not the court. We are lawyers. Determining the guilt of the accused or our client is not within our discretion. As a lawyer, it is unbecoming to reject a client on the ground of lesser chance of acquittal. We can only do so when there is apparent conflict of interest, or we will be compelled to do a legal act in order for the client to win the case. That's it.
It is not one of the grounds to refuse accepting the case in that situation. So there are, in my case, there are a lot of clients that has had lesser chance of acquittal, but I still accept them. There was a lawyer who advised me to not to accept that kind of cases actually, because it will tarnish my example reputation as a young lawyer, because the chance of losing a case is high. He said that I will just accept winning cases to improve my reputation or marketability, but here in Surala, the clients have, as I said, nowhere to go, so I just accept them no matter what are the odds in winning their case. And also, even though they has a lesser chance of winning the case, their rights must still be protected.
If there is no conflict of interest, I don't see any problem, no, of you offering your friend's surety company, no, and even if there is a possible conflict of interest, for as long as there is disclosure, diba? Basta sinabi mo, diba? Na parang I just informed you, ito may this is a surety bond, no, I'm part of this surety bond. No, I'm part of this company, maybe he's an agent also, but you've disclosed it to the client, I don't see any problem. No, again, the rule is that the client must just have to be aware, no, because you are protecting the trust and confidence of the client, that you are not doing an act that will be detrimental to his interests. Diba? Ganun lang naman yun. But if you are doing an act that will advance his interest, then, and you opening that to your client, I don't see any problem.
Majority of clients that I am handling right now are non-paying clients. Only about 3 of them are paying. The rest are pro bono. And based on my experience, I have one pro bono case where the private complainant is a prominent personality in Glan Sarangani province. Despite that, I believe the case will be resolved on merit. No? As I have high regard and faith in our judiciary.
It's been so long, no, yung public office is a public trust. It is nasa constitution siya actually. So if you are a public servant, you're always going to have to remember this provision under the constitution. The public office is a public trust, and nasa dulo nun, di ba, lead modest lives. So, for me, I manifest this mandate through filing itong statement of assets, liabilities, network. So you're going to disclose your assets and liabilities in the network, including any conflict of interest that would affect my impartiality and integrity as a public servant. So another one is that I exercise reasonable spending of government fund whenever you have or I have authorized travels, no? And go for cost-effective solutions for government functions. So with these principles, no, of honesty, professionalism, and integrity, I can safely say that I serve the public interest and maintain this interest bestowed upon me, no, as a public servant.
It's basic for me. I am not used to living a lavish and extravagant life in my childhood, even up until now. Hindi nga ako mapagkamalang lawyer.
Siyempre, ang iisipin mo, yun nga, public office is a public trust. So, alam naman ninyo that under the Constitution, a public officer must always be accountable to the people. Why? Because the people is the sovereign. Sovereignty resides in the people. We are servants. We in the government service, public officials, employees, we are servants. Yung sinasabi nila na huwag maggamit ng mga jewelry, no, na mga ano, no, na kasi siyempre ang siniserve natin yung people, lalo na in the Philippines, we are third world country. Usually ang ano talaga class na ano natin sa mababang case, no, marami talagang mahirap dito. So kumbaga careful lang tayo.
Personally, considering that my spouse is also a public servant, we endeavor to live within our means, and to live within our means refers to maintaining a standard of living in accordance with the income that we have correctly stated in our statement of assets and liabilities and net worth, as well as the income tax returns. And of course, we strive to avoid actions that tend to give the appearance that we are flaunting or living extravagantly, or we are doing our best to never use our power to show that we are more important than others. So we show fairness and justice in everything that we do.
Yes, we are allowed to represent even the immediate family or those that are within the 4 civil degrees. I have a relative once. I have a relative who has a case, and I represented her. So from the start, I see to it that, or I explain to them that when I accept their case, there are certain standards or ethical standards that needs to be observed. Although the fees might be reduced because they are my relatives, the ethical standards must be observed, like example the confidentiality and other aspects of connected to ethics. So for that client, I explained that they do not need to pay higher than what I billed them, but if they insist, I will just accept, because somehow it is rude to refuse their payment, and I just say thank you to them. I may add, somehow in that kind of client, somehow the legal services that you provided them, somehow they view it higher, or the value to them is much higher compared to how we value those services. Because there are other services that really helped them a lot. So they are willing to pay more for that.
Wait, ang framing ta, di na ako maglantaw.
Pwede sa
Diri lang sana.
Or dili sa ako.
Pwede ba
Discuss
sa-
kami.
Cut!
Nawala ka naman. Okay, cut. Cut again. Take 2.
Bombastic side-eye.
Extravagant is a heavy word. Ano yun eh, superlative, extra, di ba? Sa mga pak choy, extra, special,
special.
Napaka-extreme. So, pwede lang din siguro.
Good morning. We are here to interview one of the attorneys of to start. Ikaw na, team leader.
Ano gusto mo sabihin? Ako ang mapasama dito!
Asyong team leader.
Sige na, ikaw.
So, wala ka sabihin ako lang lahat.
Tama na, nahihilo na ako. Tama na.
Minsan mo, no?
Ikaw na siguro ang nainitan sa hot seat.
Paano masabi?